15 pages. And I show that there's not a single prepositional phrase, that this is a document with 5,000 syntax wrong words and 1,000 words that mean no contract, and therefore you have 6,000 mistakes and 5,000 words. This is like building a space shuttle to go to the moon. It's an engineering exercise on 64 million mortgages. When Lloyd's of London got a copy of this, they canceled 64 million title insurance policies in the United States. If I'm blowing smoke, then what's the world doing canceling the United States contracts across the board, shutting down the mortgage industry? And as Pandora, yes, I'm responsible personally for the entire collapse of the mortgage industry and why all of you are probably in foreclosure right now.
What does Bernanke's deal with $40 billion per month?
$40 billion, that's nothing.
Is that tied to this mortgage, to the syntaxing thing?
No, he's just trying to put a Band-Aid on something, saying we're going to buy up all your bad paper. Now, for the mortgage people, and this goes with that. Here's how the plan works. We have a document that's a fraud. And this is an autograph, this is a confession. As you know, the bank did not sign any of your mortgages. So therefore, you have what's called a unilateral contract, meaning one signer, which means it's not a contract. You are classified as a borrower or a trustor, ending the word in OR, making you responsible for what? A contract that's written in adverb verb and says nothing. You are responsible to pay back money to a contract that doesn't exist. All the money listed on the document is in a parentheses. So if we have quotation marks, a parentheses, square brackets, or we write in italics. Kind of bad. Or if we write on an angle called italics, it means it's removed from the paper and it's blank, which is the condition of all your cases. All right, so we have this document here, and this document says that the bank wants this from you. But he never signed it. So can I prosecute this individual? Well, I don't have a victim yet. You guys have become victims, but only after the fact. Those that are all current in your mortgage payments, you still are sitting on bad paper, but nobody's taking responsibility for it. You've paid, kept your mouth shut, the bank's kept their mouth shut, and you just keep paying. Well, that's cool. Your credit rating reflects that you have made a promise to give something back to somebody else, and you've kept your promise. It's just like a handshake. There's no written contract. This is not a written contract either, until I stand up in front of the court. Now, when the bank stands up in front of the court and says, I wrote this, I'm taking responsibility, I want that house, I now have a signed confession in front of a judge that they took responsibility. Now, it's my responsibility under Title 42, 1986, as a federal judge, to syntax this document and find out what it really says. What it really says is that the false misleading information, fictitious conveyance of grammar, perjury, and deprivation of rights under coloring of the law was now a condition of criminal activity under Title 42, 1986. While engaged in criminal activity under Title 42, 1986, he had knowledge because there's 6,000 mistakes without any kind of modification. In other words, it's a perfect fraud. A perfect fraud because we're back into the no law or fact. And so now he's got this no law or fact document that he's confessed to. Well, from the first one that we did in January of 2008, which collapsed the entire mortgage industry and took the stock market from 14,000 down to 6 and back up again, and put everybody into your quandrum, why hasn't the bank foreclosed you after 90 days? Why didn't they just come out with the sheriff and kick you off the land? Well, that's because we still hadn't had the banker stand up and say, I did this. So when he did that, he now had what he did was, on the 90th day, he filed a Title 46, Chapter 16, Section 781 salvage claim on your land. They killed the Indians, they stole the land, they sold it to an unsuspecting buyer back in 1800, and it hasn't been, or 1834, and hasn't been corrected to this date, and so the word is ailing, A-I-L-I-N-G. Comes from the word failing, with a square bracket around it. Better known as the Federal Rules of Civil Procedure 12b-6. Now, every one of you that have ever worked with me, the first thing that the lawyer does is he failed to state a claim. Okay, what that says is pronoun, adverb, future time, verb, adverb, verb, which means you didn't use a verb in your document. You actually sued them with correct facts, using forensic evidence with a signed confession from the bank who stood up and said, I wrote this. Now, I have permission as a federal judge under Title 42, 1986 to prosecute this individual for false misleading information. So, all the people that have filed these lawsuits since January 2008, they're stonewalled. We want more information. We want interrogatories. We want affidavits. We want a smoking gun. We want. The point is, the word interrogatory, INT, means no contract. Affidavit, AFF, vowel two consonants, means no contract. We want no contract. We want you to participate in nonsense for 3.5 years of no contract to keep you into a verb fiction. Which means as long as you say nothing about nothing, you can't prosecute nothing with nothing. Which part of no don't you understand, the N or the O? Okay. Now that this fraud has been perpetrated, we go ahead and say, well, I have the signed confession here, and the bank won't settle, and the court won't settle. They're going like, well, the lawyers all, both sides, want more and more information. Well, and the U.S. Attorney's Office in California, they said, well, we've got to find out who wrote this. I says, well, first off, this is owned by a corporation. A corporation is a dead entity, just like this piece of paper is a dead entity, is a vessel in dry dock. Even though you have a president and a vice president, a director of a corporation, who is this individual? He is not a living, thinking entity. He is a corporate trustee. Trustees are created by paper documents. There is no living person to look at. You only have a machine run by a set of rules and regulations. That machine creates the trustee and tells the trustee what to do. But all the language is written in fiction. So what is the subjective interpretation of nothing? Well, at some point here, we have to come to a settlement. So how do we get these people how do we get the machine, the corporation, to sit down and confess to a U.S. Attorney's Office that, yeah, we're responsible, yeah, this was engineered as a lie, yeah, somebody's got to pay. Well, the fine is $25 million times 64 million homes. That's $400 trillion. That's pretty big check to write. The United States Treasury is $17 trillion in debt. The United States Treasury might be $17 trillion in debt, but the United States banking industry has stolen $700 trillion from the United States Treasury in the last 84 years. So what do they do with all that money? Where's it sitting? Well, it's sitting offshore. It's sitting in trusts. It's accumulating interest. And the bank owes the United States government $400 trillion. That's according to just for the mortgages. That's only for 64 million mortgages. That's not counting all the industry, corporations, licensing bureaus, Department of Transportation, and everything else. So this is a really big number, probably $1,000 trillion. Point is, we're only going to deal with the mortgages right now.